Good morning and welcome to the Whistleblowing webinar from the 3PB Employment Group. This is part of the Employment Group's webinar series. My name's Karen Moss. I'm Deputy Head of the Employment and Discrimination Group within Chambers, and I'm joined by the brilliant Colin McDevitt. In a moment, I shall pass on to Colin and he will go through the key concepts of whistleblowing, including some updates, some of the newest case law, and he will also cover interim relief. I will then deal with detriment under section 47B in particular, and go through the new procedural considerations that we all need to bear in mind as employment practitioners. I should mention at the beginning, you're all muted, so there'll be no answering back or heckling today, sorry to the disappointed. If you have any technical issues, please use the chat function at the bottom of your screen, and hopefully Delphine in our marketing department will be able to help you. If you have any questions, please similarly post those questions in the Q&A box at the bottom of your screen, and Colin and I will endeavour to answer as many of those as we can at the end. The PowerPoint presentations themselves, so all the slides that you'll see from both of us today will be sent to you later, so you needn't make furious notes on the content of those slides. The video of the webinar will also be distributed to everybody within a couple of days, so that you can pass that on to all of your friends and watch us again and again and again. We intend to finish at noon promptly, so that we can let you have an early lunch. Without any further ado, I shall pass the virtual baton to Colin McDevitt. Thank you.
Karen, thank you very much. Welcome all. Thank you for joining us. I'm just going to start my screen share so that you can see the slides that I've got open for you. Just bear with me a second. So hopefully you can see my slides there. So I'm going to be talking to you this morning about the key concepts of whistleblowing, and then finishing off at the end with discussion about interim relief, which is something that claimants can apply for very early doors on in the life of their claim. And so in terms of key concepts, these are the things I'm going to be discussing with you today. First of all, the protection that is available to people who make qualifying disclosures. Secondly, who is it who gets that protection? What is it that they have to do in order to get the protection? Fourthly, I'm going to talk to you about some concepts in relation to definitions of what information is, public interest and how that works, reasonable belief. And then a couple of quick slides on geography and bad faith before moving on to causation and the reason for the treatment that the person complains of, and of course the need for a causative link between the qualifying disclosure and the treatment that is meted out. So those are the key concept points. I'll start off first of all then with the protection that's available. So anyone who makes a protected disclosure or qualifying disclosure has protection in law from suffering a detriment as a result of making that disclosure. And we see that in section 47B1. All of the sections that I quote in my slides are from the Employment Rights Act 1996. People are also protected against being dismissed if they have made a protected disclosure, and in fact it's an automatically unfair dismissal if the reason or the principal reason for that dismissal is that the worker has made that protected disclosure, section 103A of the ERA. Note, there is no qualifying period of employment in order for a worker to gain protection of the whistleblowing legislation. So it is instant. There isn't a 1 year or 1 month or whatever other period that a worker needs to be working. And so from day one of employment, they are protected if they make a disclosure. Who is it that is protected? Well, perhaps not surprisingly, employees are protected, but also within the legislation under section 43K, workers. Workers are a defined class of people who have the protection. That includes agency workers, people who work at home, home workers, but also contractors under the control of an employer. So they also have that protection, as do workers who are working under statutory schemes, such as you see on the slide, dentists, opticians, pharmacists. If they provide their services under a statutory scheme, then they also get the protection. So that's NHS workers, perhaps not those in private practice, although I'm going to talk to you at the end about a case called Tare Berg, which is about a dentist who was in private practice who did get protection of the whistleblowing legislation. Other people who are protected, trainees who are on vocational work experience, also members of limited liability partnerships, in the case of Clyde & Co. against Bates van Winkelhoff tells us that. That's a case, Clyde & Co. against Bates van Winkelhoff in the Supreme Court in 2014. Lady Hale said in that case that the policy of whistleblowing protection is applicable to businesses and professions that operate within tightly regulated fields, such as financial and legal services. And so therefore you might expect that people who are tightly regulated ought to be protected from making disclosures of wrongdoing. And generally the commentators in relation to this area suggest that the direction of travel of those people who are protected in relation to whistleblowing is that more people, it's a wider definition of worker that is likely to be accepted by the courts. So what is said is that the protection won't be lost by a restrictive interpretation of who a worker is. So as I say, likely to be a wider pool of people who are protected rather than a narrower pool. Other people who are protected are judicial office holders. This is the recent case in the Supreme Court of Gilham against the Ministry of Justice. District Judge Gilham was working, and I'm sure is still working, in Warrington County Court. She made a number of complaints about funding within the legal system, saying that there are cuts in the administration of justice, and those cuts are likely to lead to a miscarriage of justice. So as a result of making that allegation, she says that she was subject to a number of reprisals on the grounds that she made a whistleblowing disclosure. At all levels of the tribunals and the court, so that's the ET, the EAT, and the Court of Appeal, those tribunals and courts found that the definition of a worker, which we find in section 203(3)(b of the ERA, so that's commonly known as Lim B workers, didn't cover judicial office holders. But what was said in the Supreme Court is that the European Convention on Human Rights, Article 14, prohibits discrimination in employment in relation to all convention rights. One convention right is the freedom of expression. And so if somebody is discriminated against on the basis of freedom of expression, and the key point is here, if they have any other status, then they get protection. And so what the Supreme Court found is that section 233(b), which is the Lim B part of the Employment Rights Act, should be read to include office holders. So the words that are added into 233(b) are to include an individual who works or worked by virtue of appointment to an office whereby the office holder undertakes to do or perform work personally. So that is an interpretation that not only covers judicial office holders, but is likely also to cover the clergy and also statutory directors. So as I say, there's a widening of people covered there. So that's protection. Who is protected? What is it that someone has to do in order to get the protection? Well, this is section 43(b) of the ERA. What they have to do is they have to disclose information, and they have to have the reasonable belief in the person making the disclosure that the disclosure is made in the public interest, and they have to have the reasonable belief that the disclosure tends to show at least one of the 6 categories in 43B1. So there are a number of elements to that I'm going to discuss in a moment. What is information? How do the courts interpret that? And how is reasonable belief in the public interest looked at, and reasonable belief in showing that one of the 6 categories has been infringed. So dealing with those 6 categories, there are really 5 categories, and then the 6th one, which is F, is concealment in relation to any of the above 5. So those are criminal offence is being committed, a legal obligation is breached, miscarriage of justice, which is the one that we heard of in the case of Gillam that I mentioned a moment ago, health or safety is endangered, or environmental damage, or, as I said, number 6, concealment of any of the above. And they're written in the statute as past, present, and future. So, for example, with criminal offence, one has been committed, one is being committed, or one is likely to be committed in the future. So the disclosure has to cover one of those 6 categories. If it doesn't, then it's not a qualifying disclosure. I said I would mention information because there has to be a disclosure of information. And perhaps one way of looking at this is to have a look at this slide, because in argument in the case of Cavendish Monroe 10 years ago, this was the example that was given, and it's useful. So if one contrasts a bare allegation, and that's an allegation which doesn't convey any facts and therefore wouldn't be qualifying disclosure, contrast that with information which does convey facts. And the 2 bullet points that I've set out for you here illustrate the difference between these 2 aspects. So the first one is these words: health and safety requirements are not being complied with. So that is a bare allegation. It's not a qualifying disclosure. It's a fact in opinion, in my view, that health and safety requirements aren't being complied with. There are no facts that the person receiving that information is receiving to explain in what way the health and safety requirements are not being complied with. Contrast that with words below, which are these: the hospital wards have not been cleaned for 2 weeks and there are sharps lying around. That is a qualifying disclosure, because the information is the wards haven't been cleaned for 2 weeks, sharps are lying around. So that is a qualifying disclosure as compared to a non-qualifying disclosure. Context, though, might be important. And we see that on the next slide. Because in the first bullet point, I've set out for you these words: health and safety requirements are not being complied with. Now, as we saw in the previous slide, that in itself isn't enough to amount to a qualifying disclosure. But if those words are said in the context of pointing to sharps that are left lying around, then that is potentially a qualifying disclosure. And that was said in argument in the case of Kilrain in 2016. So I say context may be important. A series of complaints, when taken together, can be amalgamated if they are linked in some way. So again, that is a useful contextual aspect of things. But wholly separate complaints, if they are completely unrelated, won't be aggregated. So there we are. That's information. Context is sometimes important. So some examples here. Disclosure of information which tends to show something like defamation would be a qualifying disclosure, because under 43B 1B, that's breach of a legal obligation. The legal obligation is not to defame someone's reputation. That's a tort, and so that could well be a qualifying disclosure. Whereas disclosure of information in the second bullet point, which just tends to show inappropriate behaviour, won't qualify. Move on to public interest. The key here when looking at the public interest is that the disclosing worker has to have a reasonable belief that the disclosure was in the public interest. And so most commonly, the sort of cases that we see in the tribunals are claimants who are complaining perhaps about a breach of their own employment contract. That's not going to pass the public interest test, because it's a private dispute. It is always useful to consider all the circumstances to see whether the public interest is met. And 4 bullet points here, which I think might be of use to you when making that assessment, are the number of people whose interests are served by the disclosure. The more people who are affected perhaps makes it more likely that the disclosure was in the public interest. The nature of the interest and how important it is, key thing to look at. Whether the matter complained of was deliberate, so deliberate wrongdoing is more likely to be a qualifying disclosure than negligent wrongdoing. And the identity of the wrongdoer, so someone who perhaps is a regulated person like an accountant, lawyer or doctor or somebody like that, may well be more likely to be in the public interest because what they do, if it is wrongdoing, is going to have more of an effect on the public. It is sometimes an avenue for argument in terms of being a respondent to undermine the claimant's view that something is in the public interest by arguing that, in fact, at the time they didn't have a reasonable belief that the disclosure was in the public interest. And in fact, the disclosure that they were making was just because they were a difficult person. And I had a case a year or so ago where somebody who was making what they said was public disclosures was actually doing it because, as the judge said, they were a member of the awkward squad, not because they actually had a reasonable belief that what they were saying was in the public interest. So that is one way for a respondent you can undermine the claimant's alleged belief that what they were doing was in the public interest. So in this slide illustrates that point, that if the disclosing worker is acting out of self-interest, then that's not going to be a qualifying disclosure. The fact that it could have been a qualifying disclosure is irrelevant if they didn't believe so at the time. So the test is twofold. Firstly, did the worker have the belief that the disclosure was in the public interest? And secondly, if they did have that belief, was that a reasonably held belief? So there's a subjective and an objective element to it. And in fact, it is an error of law if a tribunal finds a qualifying disclosure without making those two findings of fact, i.e. that the belief was held and that it was reasonable. There's a case authority for that. Two quick slides. Geography is irrelevant, so it doesn't matter where the failing is said to be happening or will happen or has happened. It doesn't have to be in the UK. And the applicable law doesn't have to be UK law. So, for example, somebody might say, well, we are doing something that is damaging the environment in India. That would be a qualifying disclosure. Or equally, something is happening that is a breach of Indian law. Again, would be a qualifying disclosure. And if there is treatment that's a detriment or dismissal because of that, then that could well found a successful claim. Bad faith. Disclosures can be made in bad faith if they are subject to a 25% reduction in compensation. There, of course, has to be causation between the disclosure and the reason for the treatment. So for dismissal, the dismissal has to be the sole reason or the principal reason for the dismissal, section 103A. And it doesn't matter, it matters not if the employer dismisses thinking that the disclosure isn't a qualifying disclosure, and the tribunal later goes on to find that in fact it was a qualifying disclosure. It doesn't matter that the employer didn't think that they were acting unlawfully in dismissing in relation to what they thought wasn't an actionable disclosure. That in fact will be an automatically unfair dismissal if an employer chooses to do that. Maybe in terms of causation, the worker was dismissed not because of the disclosure that they made, but because of the way that they did it. And there are 4 cases that I've set out for you there, which illustrate that concept. I'll just briefly talk about the last one, which is the case of Riley, which is the EAT case of last year, heard by our very own 3PB's own Matthew Gullick, who was sitting as a Deputy High Court judge in this case in the EAT. It's a useful case because it shows the distinction between, it reinforces that you can argue that there's a distinction between the manner of disclosure and the information that was disclosed. but also it is interesting because it also sets out there's a need to identify which of the 6 categories of wrongdoing is being infringed, and it needs to be done with some degree of particularity. So Riley was a case involved a mortgage underwriter who was employed by the respondent, and he alleged in a meeting these things. The respondent was lending money to applicants with a poor credit history, and the respondent's lending practices breached regulatory requirements. Those are the things that person said. Next day, dismissed, but the employer says, well, you're dismissed because you're generally negative, you're dismissive about this company, and because of the way that he had dealt with his staff. So I say, Matthew Gulick said that it's established that a tribunal can legitimately draw a distinction between the information that's disclosed on the one hand and the way that it is disclosed on the other. And also said in relation to the need to particularize 43B1 category, he says that it's not possible on the facts found by the tribunal to say either that the claimant made a disclosure covered by 43B1B, where the breach of the legal obligation was obvious, or that he identified sufficiently or at all within the disclosure itself the legal obligation said to have been breached. It's the tribunal's findings where the claimant had complained about working practices and procedures generally. So it was a general gripe about it, rather than saying, for example, we have breached the regulatory requirement of whatever the regulation is in whatever statutory instrument it is that they're looking at in this way. Not sufficient enough. So interim relief, a couple of slides on this. A very powerful tool for claimants, because what it does if a claimant is granted interim relief is that the contract of employment is continued. And that means claimant will continue to receive pay, will continue to receive benefits, holiday accrual, pension payments, etc. Very useful for claimants. Not only because they carry on getting paid from the outset of their claim until, I don't know, what, 18 months later, which is when we're now having full merit hearings in some cases. They get paid for all that period until final determination, but also a very powerful tool because if at that final determination the claimant then fails in their claim of having made a protected disclosure, they don't have to pay any of that back. So there's no recovery of the salary that was paid in the interim. Only certain unfair dismissals will qualify for interim relief. Whistleblowing is, of course, one. Other things tend to be health and safety, representative trade union activities, occupational pension activities, and those sort of things. So not a wide range of groups of people, but whistleblowers are one. They are rare. I have dealt with 2 applications for interim relief, and in both of those the claimant failed. Maybe that'll change though in the future. Perhaps because of COVID-19, people will be going back to work and saying, well, my workplace isn't COVID secure anymore, and that's putting my health or safety at risk. And if they're treated, if they're dismissed as a result of that, they may well make a claim for interim relief in the meantime. But we'll wait to see. The test for succeeding in an interim relief application is the claimant likely to succeed? And as you'll see in the second bullet point on this slide, the claimant has to show that they're likely to succeed on all issues. So that means likely to succeed on the fact that they made a disclosure. They've got to show they're likely to succeed on whether it's a qualifying disclosure. They are likely to succeed on whether they had a reasonable belief it was in the public interest. They have to be likely to succeed they had a reasonable belief that the category, one of the 6 categories was covered. And they have to show that they're likely to succeed that the reason that they were dismissed was because of disclosure, and likely to succeed that they have the correct employment status or category of worker who is protected. That's quite a lot to succeed on. And likely to succeed means pretty good chance of success. So that's higher than on the balance of probabilities. It's a higher standard than just 51%. And that perhaps explains why on the 2 cases I've been involved with, claimant didn't get their interim relief. Final thing I want to talk to you about is the case of Hancock against Terberg, which deals with an application for interim relief. This was the dentist that I mentioned right at the outset of the start of my part of the webinar. Dentist was working under an associate agreement with a license to practice dentistry at the premises. So not necessarily an employee, but an associate agreement. He was dismissed and he made an application for interim relief. The respondent opposed that, saying, well, you ought not to hear this application for interim relief. What you ought to do first, Judge, is to have a preliminary hearing to see whether Mr. Terberg is an employee or not. And the tribunal refused that, and in fact heard the application for interim relief, saying that we declined to postpone the hearing. The interim relief application is by its very nature a provisional assessment of whether the applicant is likely to succeed. That likely to succeed test covers both the reason for the dismissal and any dispute as to whether the applicant was an employee. So there you have it. That's what the tribunal looked at. The tribunal went on to hear that application, found that Mr. Terberg had a pretty good chance of establishing he was an employee and that he'd been dismissed for making a protected disclosure. And so interim relief was granted in that situation. So that's a very quick canter through the key concepts of qualifying disclosures and interim relief. That's a photo of me, and I'm now going to hand over to Karen, who's going to talk to you about new procedural considerations and detriments. So I'll stop sharing my screen and allow Karen to share her slides.
Thank you very much, Colin. I shall try now to share my screen. Hopefully you will now see the first of my whistleblowing slides. As Colin said, I'm going to be dealing with the latest procedural considerations and the definition of a detriment. And I'm also going to be dealing with the applicable procedures for interim relief. So starting off with a procedural consideration that we all face when faced with whistleblowing cases, pleadings. IGMA and Nottinghamshire Healthcare NHS Foundation Trust is a salutary lesson really for practitioners who plead these types of cases. And I think it's fair to say that neither of the representatives really covered themselves in glory in this case. Mr. IGMA was a consultant psychiatrist at Rampton Hospital, and his initial particulars of claim were described as a long narrative, and the grounds of resistance in return were described as a long counter narrative. Mr. IGMA alleged a number of whistleblowing detriments and other claims in addition. The respondent said right from the outset that they needed further and better particulars to respond adequately. In January 2018, the claimant, in response to the respondent's criticisms of his pleading, produced a, wait for it, 142-page Scott schedule. Doesn't your heart leap? And even then, what the respondents suggested is that it was insufficiently clear and detailed to enable them to respond. So this went before a judge in the Employment Tribunal at a preliminary hearing in June 2018, and she tried to set out to the claimant what was wrong with the Scott schedule. She then ordered the claimant to complete a template, and I'm not sure how many of you have come across these templates in whistleblowing cases, but they're actually quite helpful, particularly to litigants in person, but even to experienced practitioners. In relation to the disclosures, the judge required 6 things of the claimant in terms of pleadings. First, to whom was the disclosure made and when? Secondly, what information was disclosed? And she was clear that what she required is either a description of a verbal conversation that was had, or attaching the email or the letter that was relied upon. Third, how was the disclosure made? In a meeting, on a phone call, in an email, etc. Fourth, which part of section 43B(1) was relied upon? Which of those 6 thresholds were relied upon? Fifthly, if what was relied upon is section 43B(1)(b), that is in relation to a legal obligation, the claimant had to set out precisely the legal obligation relied upon. And finally, if the disclosure was made after June 2013, then he had to set out the basis for alleging that the disclosure was made in the public interest. This template also set out what was required in terms of the detriment. So in terms of the detail that any claimant is required to include in their pleadings, 5 points. First, what was said or done to the detriment of the claimant. Secondly, by whom was this done? Thirdly, what was the date? Fourthly, what was the relevant protected disclosure? That is, which disclosure caused the detriment? And then finally, why was it said that the detriment was caused by the disclosure? The claimant failed to complete the template, at least certainly not to the satisfaction of the respondent. He did rely upon 21 disclosures and 15 detriments. The respondent applied for an unless order at a preliminary hearing a couple of months later in August 2018, and that was granted. The unless order sought to compel the claimant to complete that template that I've just set out. It's probably fair to say he did try. What Dr. Ajma did is he set out most of the detriments and the disclosures in some detail, but some of those questions were answered rather vaguely. For example, in relation to what information was disclosed, the claimant in some cases simply disclosed a letter without identifying precisely what part of the letter was relied upon as a protected disclosure. Or he said, for example, concerns regarding staff and patient safety, in particular that a risk assessment and plans should have been put in place to protect health and safety of staff concerning boundaries. So again, not really setting out with any precision precisely what the disclosure was. I should also say, in relation to detriment, Mr. Ajma set out in answer to some of the detriments that the detriment was derogatory and demeaning email correspondence. Again, no precision really as to what it was about the email that was derogatory or what words were used, etc. The employment judge found that there had been material non-compliance with the unless order and simply struck out the whistleblowing case in its entirety. The claimant obviously appealed and argued in the EAT that there was only minor non-compliance. The unless order itself didn't require him to identify which part of the letter was a protected disclosure, and the employment judge should have given him another chance to particularise his case properly, particularly where some of the claims, that is, some of the disclosures and some of the detriments, were adequately particularised. So it was wrong, the claimant argued, to have dismissed the entire whistleblowing claim. His Honour Judge Auerbach in the Employment Appeal Tribunal agreed that the whistleblowing claims in their entirety should not have been struck out. However, he did consider that some of the claims under section 47B could be struck out. What he found, passing to the next slide, is that this kind of detail on the disclosure that I've already set out, and also that detriment, derogatory and demeaning email correspondence, is simply not enough detail to enable a respondent to respond. And that's really the crucial question. Was the respondent fairly enabled to respond? Some of those disclosures were so insufficiently particularised, even after the very lengthy particulars of claim, then the Scott schedule, then the template being completed or partially completed. So some of those claims remained struck out. So what do we learn from IJMA? I mean, I suppose it's obvious that we must be very careful when we are pleading claims in whistleblowing for claimants. It's really important that we concentrate on the types of things that the employment judge set out in that template, and in particular, the legal requirements under section 43B must be borne in mind. It's also the case that, in my experience, many claimants are really keen to include as many whistleblowing disclosures as they can, because they think that that puts themselves in a positive light and it puts the respondent in a negative light. That is not the way to plead a whistleblowing complaint. Practitioners must focus on the disclosures which are most likely to satisfy the threshold tests of being a qualifying disclosure, and they must also look to which of those disclosures were most likely to be causative of the detriment or dismissal, and that is probably going to be the disclosures that were made closest in time to the detriment or dismissal. Scorching hot off the press, the case of Vaughan and Modality Partnership. It was only handed down on the 9th of November, a few days ago. His Honour Judge Taylor's judgment struck a chord with me in relation to pleadings. He said, and this case was a case about an amendment in a whistleblowing case, but he said this at paragraph 41. In all public interest disclosure cases, the focus should not be on how many disclosures can be asserted and how many detriments can be alleged, but on which disclosures are likely to be shown to have given rise to a detriment. Litigants in public interest disclosure cases often feel with detriments and disclosures that the more the merrier, whereas focus on the principal disclosures that may have resulted in a detriment or dismissal is more likely to bear fruit. So that resonated with me. I know that it is very common to have litigants who think the more the merrier in relation to disclosures and detriments. It's not the way. If you are for a respondent, it is important to put pressure on the claimant to adequately, to particularise their claims adequately. And if they don't, because it is quite difficult, particularly for litigants in person, to particularise their case to the satisfaction of the tribunals. If they don't do so, then of course it is a good idea for respondents to ask for further and better particulars early on, and to apply for unless orders if those further and better particulars are not forthcoming. Also, it is a good idea, in my experience, to apply for preliminary hearings to determine whether any particular disclosure or disclosures were protected. Again, in my experience, you're more likely to get a preliminary determination on that point if, first of all, the whole case is going to be determined by whether the disclosures were qualifying or not. And if the disclosures themselves are agreed. If there's a factual dispute about what was said, then it is likely to be quite difficult for a tribunal to determine or at a preliminary hearing without making decisions about credibility on the rest of the witness evidence, to determine that question at a preliminary stage. But certainly these are considerations that respondents should have. Moving swiftly on to another procedural consideration, limitation. The recent case of IKEA GAQ in the Employment Appeal Tribunal before Mr. Justice Sewell made clear a very common question in employment tribunal proceedings in relation to time, where there is a detriment which is applied, which has continuing detrimental effects on a claimant. When does time start running? In that case, the tribunal found that a new contract was imposed and was a detriment on the claimant as a result of his whistleblowing. However, they found that it was nevertheless out of time because the new contract was a one-off event. So even though it had continuing consequences, the time started to run from the date the new contract was introduced, and therefore the claim is out of time. Moving now to interim relief procedure. Now, the most important word that I put in capitals there is you have to apply very quickly. You'll see, as I've set out the section 128.2 of the ERA, you only have 7 days from the effective date of termination. And there is no jurisdiction at all for an employment tribunal to extend the time limit. So although I know employment practitioners are very used to dealing with matters very quickly because we have a short limitation period, even for the normal statutory claims, this one is lightning quick. What happens leading up to an interim relief application hearing, first of all, perhaps obviously, you must set out on the face of the ET1 form that the claimant seeks interim relief. There is a box to be ticked on the ET1 form, and of course it's a good idea to include it in the particulars of claim. There's no need to obtain an ACAS EC number beforehand. The employment tribunal is required to determine the issue as soon as is practicable. And even in these COVID times where there's a huge backlog of cases and not enough judges, in the group's experience, we found that still these cases are being prioritised. Only 7 days notice is required to be given to the employer in an interim relief application. So that really does mean if you're acting for either party, you really must drop everything and concentrate on this type of application. As Colin said in his presentation, this can be an extremely valuable remedy to a claimant. It's worth fighting for, and it's certainly worth defending very hard. Postponements are only allowed if there are special circumstances justifying a postponement. In the Lunn and Aston Derby group case, the Employment Appeal Tribunal decided that although mere inconvenience was not enough to justify a postponement, in that case the claimant had instructed a barrister on a direct access basis, and that barrister couldn't attend the hearing because he wasn't available. And the Employment Appeal Tribunal disagreed with the Employment Tribunal and suggested that that was enough. Essentially, that was a special circumstance which justified a postponement in those circumstances. Moving on to the hearing itself. Generally, the Employment Tribunal does not hear oral evidence. And if it is to hear oral evidence, it will give a direction to that effect. Determination at this kind of preliminary hearing has to be an expeditious summary assessment. It's also been described, as I've set out, as an impressionistic task. This is essentially the Employment Tribunal doing their best with the evidence that both parties have managed to cobble together in what will be a relatively short period of time, and of course that evidence being untested. It's quite difficult to appeal against such an assessment because, of course, employment tribunals have a difficult task in circumstances where they don't have all of the evidence, and they're not expected to subject the evidence to the same kind of scrutiny, anyway, near the same kind of scrutiny that one would expect at a full hearing. Usually the Employment Tribunal does have the ET1 form. Well, it always has the ET1 form before it, but it doesn't always have the ET3 form. But it will have witness statements and any other directly relevant documentary evidence that's available to the parties at the time. The Employment Tribunal isn't required to make any findings of fact, because obviously any tribunal is very reluctant to make the kinds of findings of fact that will then be binding on an employment tribunal who has the benefit of hearing the witnesses and testing the evidence. Moving on to the next topic that I'm covering, detriment. So this is obviously particularly in relation to whistleblowing. This is under section 47B of the ERA. I'm dealing with a Supreme Court case that we're probably already familiar with, the Williams and Swansea University case. In that case, as you're probably aware, this was a disability discrimination case. It wasn't a whistleblowing case. And there was initially some uncertainty because the Court of Appeal suggested that there was a difference between unfavourable treatment, which is the phrase used in the Equality Act in relation to discrimination arising from disability, and detriment, which of course is the word that's used under section 47B. The Supreme Court settled this and Lord Carnworth made clear that those two concepts are analogous. So essentially there's no difference. That means that Williams is a helpful authority for practitioners dealing with whistleblowing complaints under section 47B. Mr. Williams, he was entitled to early access to his pension because of his disability. And he complained that his pension wasn't as good as it would have been had he not been disabled, because it would have been based on full-time earnings, whereas because he was disabled, he only worked part-time at the end of his employment, and therefore it was based on the lower level of income. And what the Supreme Court said, they essentially agreed with the Court of Appeal and the Employment Appeal Tribunal, treatment that was advantageous cannot be said to be unfavourable simply because it was insufficiently advantageous. Essentially, Mr. Williams only had access to his pension early because he was disabled. So this was an advantage rather than a disadvantage. Because I haven't got much time, I'm going to skip over the next case, which is another disability discrimination case, which went the other way to Williams. What the EAT said in that case is that the cap of the lump sums that were available to these police officers was the unfavourable treatment, and therefore it was distinguishable from Williams. Tip Lady and City of Bradford is worth a mention. Tip Lady alleged, or Ms. Tip Lady alleged to have encountered detriments in her capacity as a user of the council's services. And the Court of Appeal said that that was not a detriment which one could pursue under section 47B because the detriment must be in the employment field. And then moving to the most recent of these cases, Jasudison and Alderhay. This is an interesting case because the Employment Tribunal and the Employment Appeal Tribunal were agreed that the claimant had not been subjected to a detriment, but the Court of Appeal overturned those decisions in this regard. One must bear in mind with detriments that the bar is set quite low. The previous authorities have all suggested that essentially it is anything adverse. And of course, once a claimant proves that the disclosure that they made was protected and they were subjected to a detriment, that is something adverse to their interests, the burden of proof shifts to the respondent employer to prove that the detriment was not caused by the protected disclosure. So I think Jasudison helps to show how low the bar is. In that case, the claimant was a surgeon. He complained that he had been subject to a detriment when his former employers sent correspondence to members of Parliament and the Care Quality Commission, among others, incorrectly stating that his public allegations of fundamental failings in the paediatric department had been found to be wholly unsubstantiated. Now, both the Employment Tribunal and the Employment Appeal Tribunal thought that those letters did not amount to a detriment. The Court of Appeal disagreed. They found that the detrimental observation about a whistleblower in this correspondence did amount to a detriment, just because the trust was seeking to protect itself from criticism did not mean that these letters were not detrimental to the claimant. They found that essentially the letters implied that Mr. Jasudison was a liar or a troublemaker, and he was making specious or unsubstantiated complaints. So they did find that those letters were detrimental. Nevertheless, Mr. Jasudison's complaints were dismissed because they found that the cause of those detrimental letters was the desire to minimise damage to the trust and not on the ground of those disclosures. That has been a rather whistle-stop tour of the procedure in relation to whistleblowing. I think there are a couple of questions and we might have time to answer maybe one or two. I'm going to pass now to Colin to go to those questions. I'm going to stop sharing my screen. Thank you.
Karen, thank you very much for that. Yeah, there are a few questions that I've marked in the Q&A box that I'll have an attempt at answering for you. Bear in mind that there looks like there are some for Karen, but Karen's only just finished speaking and hasn't had a chance to look at the ones that were raised while she was speaking, so she may not be able to answer those. So I'll crack on with the few that I've marked. The first one is from Marianne Peters. So Marianne, thank you very much for your question. And the question is, what if the breach was a failure to auto-enroll in the pension scheme? I think, well, I'm interpreting that question to mean that what if the breach, was it a qualifying disclosure if the breach is a failure to enroll in a pension scheme? I think the answer to that is probably yes, because if it's a legal requirement to auto-enroll in a pension scheme and the worker is saying, well, you haven't done that, and it's a breach of law, then I can't see why that wouldn't be a qualifying disclosure. So I hope that answers that one for you.
I was going to say the difficulty with that one might simply be public interest, because if it's only one person who's affected by the failure to auto-enroll, there might be a difficulty there with reasonable belief that the information is in the public interest. But it might depend how many people are affected by the failure to auto-enroll.
Yeah, absolutely. I sort of had thought that it was failing to enroll the whole workforce in a pension scheme, but you're right, Karen, it might have just been one person. And that's probably illustrated actually by the next question, which is to do with health and safety, I think, from Sonia Bowler. So Sonia, thank you for your question. This question says this: would it amount to a qualifying disclosure if a health and safety officer was concerned that the death rate in a company was higher than the industry standard and the company were refusing to investigate whether the higher rate was due to possible health and safety issues relating to the company? So I think a general complaint that the death rate is too high may not convey information, and so that may not be part of what constitutes a qualifying disclosure. But if the person is saying, well, this is a breach of a legal obligation because you are required to investigate why our death rate is so high, and our death rate is high, then that potentially could well be a qualifying disclosure. Or alternatively, if the person making the disclosure is saying that our death rate is much higher than the industry standard, and that is therefore putting health or safety of our workers, is endangering the health and safety of our workers, that also sounds to me like that probably could be a qualifying disclosure. There's going to be a public interest element to that, and I think that it's likely that the person making that disclosure will be able to show they had a reasonable belief that that's in the public interest, because if the death rate is very different in their company to the industry standard, that sounds to me like that would be in the public interest. Karen, if there's anything that you wanted to say in respect of that one?
No, I think you've covered that one, okay. Colin. I think we might have time for one more. Shall I take? There is a short question from Sarah Martin. Thank you for your question. The question is: there is little case law for constructive unfair dismissal for Section 103A claims. How does this impact on the claim? I've done quite a few constructive dismissal cases under Section 103A. There's certainly cases that can be run. The way that they are run is that the claimant first has to identify essentially that they were subjected to a detriment, but that on the grounds of the whistleblowing. And then they have to show that that detriment was a repudiatory breach and caused the later resignation. So, for example, if somebody makes a protected disclosure, and then because of that protected disclosure, they are subjected to a pay cut, for example, then and then they resign because of the pay cut, that can be said to be an automatically unfair dismissal under Section 103A, as long as, of course, all the other tests are there. So as long as it was a repudiatory breach, which it probably would be if it was a pay cut, and as long as that it was caused by the protected disclosure, the person did resign because of that, and had not affirmed the contract in the meantime. Hopefully that answers some of the questions. I'm sorry to those who have asked questions that we've not been able to answer. Colin, did you want to say some final words before we sign off?
Yes, I think I'll just wrap up. Thank you, Karen. I want to just say thank you to Delphine and Lisa, who are in our marketing department, who very expertly help us with these and make all the arrangements for sending out your invites and getting this all working. Thanks also, of course, to Karen for presenting this webinar. Our next webinar is on the 10th of December. The topic is personal injury and discrimination law, and that's going to be delivered by Sarah Clark and Grace Nichols. So if you're on our database, you will get an invitation to that. So please do tune in for that. Other webinars are available on we've got a 3PB YouTube channel, and a copy of this webinar will appear on that in due course, probably by the end of this week. You'll get the slides for today's webinar later on today. If you want to have a look at some of the other webinars that we've produced, then have a look on our YouTube channel. So thank you very much. Thank you generally for our attendees. This year we've had great support on these webinars. Most webinars attract sort of between 200 or 300 attendees who are tuning in at the time, and also then other people do want to revisit things by looking at the 3PB YouTube channel. So thank you all for your support for the year. Do tune in December for the next one. That's the 10th of December. And I'd like to just say thank you very much and enjoy the rest of your day. Bye-bye.
Thank you. Goodbye.